Ready, start. The Bar Council, while referring the matter to the disciplinary committee, is empowered under Section 35 of the Act is not to write a long order stating the grounds for satisfaction, as the word used in Section 35 of the Act is that the Bar Council has a reason to believe. Full stop. About the satisfaction so recorded for referring the matter to the committee as being complained to be arbitrary, we may also hurriedly notice the facts so as to have our prima facie satisfaction in respect to the claim of unwarranted harassment. Full stop. Here is the case where respondent number 2, who is a lady, has made a complaint about marpeat, and various other charges about demand of dowry, etc., and at the same time pressure for signing the papers for the purposes of divorce. Full stop. A report in respect to the misdeeds of the petitioners was made to the local police, upon which FIR under section 498-A, 323 and 506 IPC and 3/4 Dowry Prohibition Act was lodged, and on filing writ petition before this court, the district judge and the senior superintendent of police were asked to ensure suitable protection. Full stop. The complainant also is an enrolled advocate, and she is also a member of Kanpur Bar Association, and in respect to her wishes of starting the law practice, petitioners crushed the same, and in various ways they harassed, tortured, and serious threats were extended for the life and property of the complainant and family members. Full stop. Bar Council, in the light of seriousness of the complaint, supported by series of documents duly verified by the affidavit, being was prima facie satisfied that it is a fit case for rendering the matter to the disciplinary committee for disposal in accordance with law, and thus we do not feel persuaded to accept the submission that exercise of the bar council in making reference is otherwise arbitrary, whimsical, and is a routine one. Full stop. Bar Council has clearly mentioned in its resolution that the contents of the complaint has been perused, and thus it goes without saying that copy of the complaint, the documents annexed with the complaint were all taken into account, and having a reason to believe about commission of professional or other misconduct, as the case may be, referred the matter for disposal to the disciplinary committee. Full stop. Submission of the learned counsel for the petitioner that even if the charges against the petitioners are accepted to be correct, this was not professional misconduct, is totally misconceived for the simple reason that for an advocate who is always called learned, if such kind of behavior and conduct with his wife and her family member is accepted, then it can be said to be just unbecoming as expected to be the conduct of a gentleman, what to say an advocate. Full stop. Reliance as placed by the petitioner and decision given by the special bench in the matter of H, an advocate Kanpur within bracket supra bracket close, where there is observation about professional misconduct and other misconduct is not applicable. Full stop.